Welcome back. For the next few minutes, we're going to talk about some legal aspects of writing for the media. Laws affecting communications professionals protect both audiences as well as practitioners. And if you don't understand some of the basic principles of what you can legally write as a professional communicator, you can find yourself in some serious trouble. As far as the Constitution is concerned, the First Amendment is the key piece of legislation that allows most of our freedoms when it comes to expression. Ratified in 1791, it provides significant protections for both spoken and written communication. Still, the First Amendment doesn't mean that you can say anything you want. You have to be careful not to commit defamation, the act of harming one's reputation. If what you're writing is true and it hurts someone's reputation, that is generally protected speech. However, if you lie and harm someone's reputation, it can result in costly lawsuits and humongous legal fees. Invasion of privacy is another legal area that requires careful navigation when writing for the media. Sometimes you may have information that is true, but you have to ask yourself if it is newsworthy before you publish it. For instance, is it newsworthy to publish private information such as medical conditions, sexual orientation, incidents of rape or sexual abuse, or other matters that individuals might want to keep private? It might very well be newsworthy, but you should be careful when weighing this consideration. If it can be deemed as newsworthy, then journalists can often win these types of lawsuits. However, if the information seems to hold little value in terms of news, that is when journalists or writers get into trouble. Depicting someone as being something they're not is also a big no-no. It's called casting someone in a false light. For instance, there was a case where a reporter wrote a story about parents being negligent with children at crosswalks for busy intersections. The reporter who wrote the story did not have a photo to run with it, so he grabbed an old file photo of a couple crossing the street with their kid and published it with the story. The parents in the original photo were outraged, as it implied that they were not being careful with their child. They sued and ended up receiving damages for the careless actions of the journalist. Advertising is referred to by the courts as commercial speech and has some protections under the First Amendment. However, advertisements that blatantly lie about products or services are called false advertising, and they are treated very harshly by the U.S. government. The primary agency that enforces laws concerning false advertising is the Federal Trade Commission, or FTC. Broadcasting is the last legal aspect we'll talk about. Broadcasting specifically refers to content submitted via public airwaves and is treated differently than other forms of media communication. So, if you're listening to National Public Radio on your car radio, it is subject to broadcasting regulations because you receive it via public airwaves. However, if you're listening to a subscription service such as Pandora or Spotify, they are not within the spectrum of public airwaves and therefore do not fall under the same regulations as broadcast. This is largely why shock jock Howard Stern made the decision to leave radio for satellite radio, because the Federal Communications Commission kept fining him for indecent content when he was broadcasting on public airwaves. This is also why cable networks like HBO or Cinemax can show unedited R-rated films, while stations like NBC will have to remove content with nudity, foul language, or extreme violence. Broadcasting is regulated by the Federal Communications Commission, or FCC. Well, that's all for our brief coverage of legal aspects of media writing. See you next time.